Okay, welcome everybody to the 2023 John Black Moot Court Competition final round. It's been a great competition so far. And after the speakers, after each round is over, we're gonna stop the live stream for just a few minutes while the judges score the competitors, and then we'll turn it back on. And the feed will start back for the feedback for the competitors and also for the announcement of the winners.
Okay, okay, all rise. The Supreme Court of the United States is now in session. Please be seated. We're here today to hear arguments in the case of Denal versus the city of Nur. Can I have announcements from the petitioner?
Hi,
Your name
this is going to Abache.
and Kariba Amer. Okay.
Good evening, Your Honor. My name is Gunnar Osteen, alongside my co-counsel, Mr. Ryan Fishbeck. We're representing the city of Nair in today's proceedings.
Thank you very much. Petitioner, how would you like to split up your argument for main argument and rebuttal?
Your Honor, we would like 1 minute for the rebuttal and 11.5 minutes for each of our arguments.
Okay. Respondent, how are you going to be splitting your time?
Even split, Your Honor, 12 minutes for both issues.
Petitioner's counsel, the first of you can proceed whenever you're ready.
May it please the court. My name is Ugona Abakwe, and along with my co-counsel Ariba Amer, represent William Denal, the petitioner in this case. This case deals with the fundamental principle that our First Amendment rights should be protected by our occupation, and we should not be compelled to do anything that we do not believe in. We ask that the court reverse the judgment for two reasons. One, because the appellate court applied the incorrect test by using the intermediate scrutiny test rather than the strict scrutiny test. And number two, because the appellate court's application of the intermediate scrutiny test was incorrect. Accordingly, the city of Nur denied Denal's compelled speech rights and failed to consider art's deeper meaning. I will discuss the free speech issue, and my co-counsel will discuss the freedom of association issue. Turning your attention to page 7, paragraph 1 of the record. The court used the Turner Broadcasting Systems versus FCC's intermediate scrutiny test while making a decision. This test explains that state regulations compelling speech should further an important or substantial government interest unrelated to the suppression of free speech if the incidental restrictions do not burden essentially more speech than is necessary to further those interests.
Counsel, I have a predicate question. How does the act of printing the clients in this case, that their chosen message for their wedding, and then having those individuals display that message at their own wedding, how would that implicate your client's free speech rights?
Your Honor, thank you for your question. Petitioner holds the belief that he has a company called Indulging Your Creativity. And in this company, he provides his logo on the banners of all the banners that will be shown. And the banner has his logo on it, signifying that his company is approving of these messages that they're putting out.
Well, can he also put a disclaimer saying, I don't endorse the message?
Well, two things. Number one, Your Honor, we don't think that would be practical. He had put a disclaimer on his website saying that he refuses to serve anyone for any reason. And using this disclaimer, it was broad enough to cover certain situations. We don't believe that it'll be necessary to cover every single situation where he might not be interested in serving.
What if he were just to remove his own logo? Does that make a difference in the analysis?
Not necessarily. These messages are still being portrayed by his company. And if, for example, he was soliciting business and somebody knew that these messages were written by his business, they can interpret that as him displaying that message.
I'm sorry, counsel, just to follow up. Does the statute provide for any exception to service? As you mentioned, he has a disclaimer on his website that says that he reserves the right to refuse service to anyone. Does the statute contemplate that, and does it allow that kind of disclaimer?
Well, the statute was not broad enough to answer that question for us. And because of that, we asked that the court review the standard specifically as applied to this case, rather than look at the city ordinance on its own.
Council, I also have a follow-up question. I understand your client's website indicates that he's an artist, but in this case, he's not actually drafting the words or the message. He's basically just scribing them, correct?
Your Honor, you're correct. However, it goes further than that. So my client has two different things that he typically does. So one of them is he sells like stock products, and he was still willing to sell those products to these couples. However, he thought that simply using his creativity, his fonts, his logo, his banners, and displaying a message represents that he supports those views. I would say. On page 7, paragraph 2 of the record, the court was unpersuaded that a reasonable person who viewed the product would see it as expressive conduct. Art is vague and ambiguous. Artists should be allowed complete control on how they display their art and their interpretations behind it. Not allowing an artist to relay the message and how they intend denies their right to free speech and compels them to speech in a way, or to use speech in a way that they may have not intended.
Well, isn't that just the first part of that two-part test from Spence versus Johnson? Or Spence-Johnson test? The second component is what the court focused on, which is whether there was a great likelihood that a reasonable third-party observer would understand that message the way that your client claims. How would a wedding celebratory message itself indicate that your client is endorsing something with respect to the wedding?
Your Honor, are you asking that because, can you please rephrase?
Well, to me, you're focusing on the intent, whether he intended to convey some sort of endorsement of the wedding. But that's only one part of the two-part test, right? I mean, how from a standpoint of a reasonable observer, would that observer assume the mere fact that he printed the signs or the banner means that he's endorsing the marriage itself?
Well, a reasonable person standard, Your Honor, in this case would be a subjective standard.
Well, I mean, a reasonable observer to me is always an objective standard.
Your Honor, I believe that in this situation, depending on the people that are at the wedding in question, there could be multiple different interpretations by these people that are here. So that's why the focus of our argument is on the artist and his message, his intentions Because we do not believe that the statute is broad enough to cover artists. We think it's too narrow. And it being this narrow doesn't encompass the ideas of the artist.
Well, I mean, the statute on its face it's a general public accommodation statute. So you don't disagree your client provides goods or services to the public, right?
No.
And the statute says if you provide goods or services to the public, you can't discriminate on the basis of gender, race, sexual orientation, and the like, correct?
You're correct, Your Honor. Or the only instance that we disagree with is the fact that he discriminated. He was still willing to sell products to this couple. It was just that specific narrow portion of using his creativity to further convey his beliefs. In Norwood versus Harrison, the Supreme Court held that a state cannot provide funding to private schools that practice discrimination. The court recognized that private schools have the right to exist and engage in a level of discrimination, but that it would be at the cost of receiving funding. If Danoff chose to operate his business how he wants, he should be allowed to. But the court should take a Norwood approach by setting certain limits on what resources he can receive from the state as a private business owner, but not by finding him. Danoff chose to operate his business as a private business owner. On page 7, paragraph 4, the court explained that all businesses are susceptible to reasonable regulations. In Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston, the Supreme Court held that the state's application of public accommodation laws to require private citizens who organize a parade to include a group imparting a message that the organizers do not wish to convey violates the First Amendment and is unconstitutional. In this case, private citizens that organize a parade clearly have an agenda they are trying to achieve. Similarly, Danoff choosing to privately operate his business has certain agendas and ideas he would like to be the foundational principles of his establishment. Danoff was aware that there might be some contradictions between his ideas and the work inquiries he could receive, which led him to state the disclaimer that I mentioned earlier. He's an artist, and many of his ideas are likely abstract. And back to my other point, that's why the reasonable person's understanding of art is too vague to be applied to the standard of art. For public policy reasons, applying the standard would stunt the innovation of new ideas. In conclusion, we ask the court to reverse the Court of Appeals judgment and find that the ordinance violates Danoff's First Amendment right to be free from compelled speech, because we do not want to stunt the innovation of new ideas. The test used to decide this case was unconstitutional, as it was narrowly applied to Danoff. Thank you.
Thank you.
Thank you, Your Honors, and may it please the court. As my co-counsel stated, my name is Ariba Amer, and I will be arguing the second issue that Ordinance 4B violates Danoff's freedom of association and thus should be held unconstitutional. This case highlights the importance of protecting freedom of association for individuals such that they do not need to choose between their personal religious beliefs and their income-earning occupation. The court should reverse the judgment because the Court of Appeals erred in holding that Section 4B did not violate Danoff's First Amendment free right to association. This is for 3 reasons. First, the ordinance establishes unconstitutional guilt by association. Second, the ordinance denies unconstitutionally Danoff's rights based on mere advocacy alone. And third, the city has not met its burden for establishing why the ordinance is an appropriate requirement for employment.
What rights are you indicating that the ordinance denies your client?
First Amendment rights, Your Honor.
Right, but on his website, he clearly states that he is specifically providing event. I can't remember exactly what the language was, but that he provides items for events, especially for weddings. If he did not want to be associated with a certain type of wedding, what prevents him from just saying, I'm not going to provide any event or any items for weddings in general? How would that be an unconstitutional restriction on his rights?
Thank you for your question, Your Honor. In my argument, I'm referencing Ordinance 4B, which denies Denolf's right to contract with the government because of $500 donations to 4 groups that were designated by the Attorney General. If that answers your question, Your Honor.
So we're talking about specifically the monetary penalty?
We're talking, in this case, Denolf, we're addressing the denial of determination of the contract between Denolf and the government that was longstanding for 10 years, which provided Denolf $7,500 worth of it.
I mean, isn't it true that government can choose not to fund speech, which it just objects?
That is correct, Your Honor, and that draws me to my third point, that although that is correct, the city has not met its burden for establishing why the ordinance is an appropriate requirement for the effective performance of the office. This court held in Branty v. Finkel that the government has a burden to establish that the parties group is an appropriate requirement for the effective performance of employment. Likewise, under Healy versus James, the government has a burden of establishing a knowing affiliation with an organization possessing unlawful aims and a specific intent to further those aims.
So let me ask you, that the Court of Appeals cited the Broderick case and they said, simply put, the state can treat employees differently than the average person. So you can see that point, but you're just saying that the state, well, let me ask you this, do you, in a contract situation like this, do you subscribe to that analogy that the Court of Appeals used, that that your client is an employee, or do you have some different analogy that you use?
Yes, Your Honor. In this analogy, we are drawing an analogy between Denolf's 10-year contract and employment.
And why would it be tenure if it's an annual contract?
The contract, while annual, it is important to note that Denolf has been in contract with the government for 10 years because I think it provides an additional reason why the analogy between employment and the contract should be drawn. Because Denolf, on the basis of 10 years, could have been using the income or relying the income to furthering his business, and thus removing the contract and terminating the contract on the basis of this ordinance penalizes him the same way that terminating employment.
Well, doesn't that analogy to the employment cases hurt you? Because, I mean, if an employer can treat its own employee that way and limit, let's say, circumscribe the political activities they participate in, why in an arm's length transaction can't the city decide not to do business with an independent contractor that lends financial support to an organization with which the city has an issue?
Your Honor, the analogy to the employee is important because of the Branty v. Finkel case, where the city has not established why this is an effective performance for the employment of Denolf. In Branty v. Finkel, this court held that a county public defender could not discharge 2 county assistant public defenders solely because they were Republicans. This court held that was sufficient, however, for the 2 assistant public defenders to prove that they were about to be discharged solely for the reason that they were not affiliated with the Democratic Party. And that analogy is important here because Denolf is merely being discharged because of his alleged affiliation with groups who refuse to sanction same-sex marriage. And the government likewise has not.
I mean, I don't see where the ordinance prevents him from being affiliated, going to their meetings, subscribing to their messages, attending their events. It's just a monetary contribution, isn't it?
Yes, Your Honor.
So isn't that a distinction that's notable? That it doesn't prohibit him from affiliating with these organizations, does it?
Your Honor, it doesn't, and that is correct. However, the city still hasn't established why the donation is an appropriate requirement for creating signage for the city.
And you're basing that argument on the Brantley case.
I'm basing it on Branty and Healy versus James.
Okay. But is the city making the argument that it was an employment relationship? I mean, have they conceded that?
No, Your Honor.
And so the only way that that argument works is that if we accept the idea that it was akin to an employment relationship.
Yes, sir.
If we accept the premise that every year the contract came up for a reason,
Mhm.
and then you would concede that your argument, the employment analogy wouldn't work.
Your Honor, I would like to draw your attention to within Elrod v. Burns, in support of a holding in an additional Supreme Court case called Perry, that even an employee with no contractual right to retain his job cannot be dismissed for engaging in constitutionally protected speech. And I believe that analogy answers your question here, because it is the principle of the fact that the termination of employment penalizes Denolf merely for donating to groups that the government does not support. That is unconstitutional here.
One key difference between a contract and employment relationship is that the employer sets the salary and largely the conditions of employment. But each time you renew a contract, the terms, correct?
Correct, Your Honor.
Actually, I have to follow.
Yeah.
That question.
Correct, Your Honor. However, in this contract that's lasted 10 years, Denolf and the government have been merely re-signing the same contract for the past 10 years, which is why I believe this specific situation where this contract has been re-signed for 10 years is important to drawing the analogy for employment.
At what point would it have just been a contract and not employment? After the first year, second, or the fifth? Why is 10 years important?
Your Honor, 10 years is important because of the issue that we're discussing here, which is the penalty that Denolf is facing for merely donating to these groups.
Well, given how fungible money is, I mean, isn't it legitimate for the government to be concerned that the funds that it is paying to Denolf under the contract are then just turned around and funneled into organizations that who propound messages that the city profoundly disagrees with?
Your Honor, there is no evidence on the record that Denolf is taking money that he's earned from the job, or rather the money that he's taking from the city and in turn turning it into donations to these alleged hate groups.
But that's the whole notion. Money is fungible. Like, you don't have to trace every dollar from one source to another. I mean, it goes into a pot.
Correct, Your Honor, but it is still not an appropriate requirement for him merely creating signs for the government. And the statute's purpose, while honorable to promote tolerance of all purposes, on page 3, the city's logo merely appears alongside the business's name, and I quote, "indulging your creativity." If the city's logo if the city is concerned with associating with these groups, people at first glance would not associate the business with Denolf. And likewise, viewers would have to take additional measures to find the owner of the business, and likewise the owner's donation history. And thus it is not an appropriate requirement for merely creating signage for the government and fails the test under Branty.
Doesn't that argument kind of undercut your co-counsel's argument though earlier in response to my colleague's question about hiding or deleting his particular logo from items? I understand that that's not in your wheelhouse necessarily, but I wonder if it kind of seems like you're trying to have it both ways. That the city can hide its association, but that your client cannot. You understand what I'm saying?
Your Honor, if I may rephrase your question.
Sure.
The question you're asking me is whether my opposing counsel's argument, my co-counsel's argument, that the city that Denolf could merely remove his logo.
Right.
And why that same argument does not apply here.
Similar, yeah, there's very much so. Why is it okay for the city then to kind of, remove their branding from that? Maybe I misunderstood your argument. And so maybe that's coming from a place of misunderstanding what you were just trying to argue.
Your Honor, if I could maybe perhaps repeat my argument.
Please.
In the same words and see if that same question could be resolved. My argument here is that on the record on page 3, the city's name in the contract, when Denolf is creating these materials for the city's name merely appears next to the name indulging your creativity. And thus the city does not in that manner directly associate with the 4 hate groups that are allegedly hate groups under the determination of the Attorney General. And so the argument here is that the city has not shown why it is an appropriate requirement for the performance of this office that Denolf not donate to these alleged hate groups. In Healy versus James, this court established that the government has the burden of establishing a knowing affiliation with an organization possessing unlawful aims and a specific intent to further those illegal aims. The city has the burden and they have once again not met it. Your Honor, I see I've run out of time. May I briefly conclude?
Sure, go ahead.
In conclusion, we ask the court to reverse the Court of Appeals judgment and find that the ordinance violates Denolf's First Amendment right to associate for the recent aforementioned. Thank you.
Would your honors like a little bit of time to write down comments, or would you like me to begin?
Whenever you're ready.
Madam Chief Justice, and may it please the court. My name is Gunnar Osteen. Alongside my co-counsel, Mr. Ryan Fishbeck, we'll be representing the city of Nair, who is the respondent in today's case. This case is about the importance of promoting the common good. It is a common good that individuals not be discriminated against at the point of sale. And it is a common good that the city not be forced to uphold contracts with people who violate its laws. Now, this court should affirm the lower court's decision for two reasons. First, the Court of Appeals correctly found that Section 3 of Ordinance 417, as applied to Mr. Denolf, did not violate his right to be free from compelled speech under the First Amendment. Second, the Court of Appeals correctly found that Ordinance 417, Section 4B, as applied to Mr. Denolf, did not violate his right to free association under the First Amendment. Now, I will be discussing why the court was correct in its determination on the free speech issue, and my co-counsel, Mr. Fishbeck, will be discussing why the court was correct in its determination on free association. This court should affirm the lower court's decision regarding Section 3 as applied to Mr. Denolf's right to free speech because it correctly found three things. First, that Mr. Denolf's work was not artistic expression and protected under the Spence test. Second, the Court of Appeals correctly found that Section 3 is a content-neutral regulation and thus subject only to intermediate scrutiny. And finally, the Court of Appeals correctly found that Section 3, as applied to Mr. Denolf, passes intermediate scrutiny. I will take each of these in turn, starting with my first point. The Court of Appeals correctly found that Mr. Denolf's work was not protected under the Spence test and thus not deserving of First Amendment protection.
Well, although certain components of what Mr. Denolf did were essentially printing, fonts, maybe that is a subcategory of the services sought. But my understanding is that Mr. Denolf was also asked to create new art for this couple, right? I mean, how is that not some sort of free expression?
Your Honor, I think a similar analogy would be essentially a furniture builder. Now, a furniture builder may have certain requests come from a client, well, let's say a chair. Now, in that request, the client may include certain specifications like color, size, dimension, but ultimately it's not artistic expression when the craftsman builds that chair. Rather, he's simply applying the order from the customer and creating the product.
But some of these were Mr. Denolf's original ideas, right?
Well, actually, Your Honor, on Mr. Denolf's website, as noted on page 3 of the record, he expressly states, whatever you imagine, we create. The actual artistic intent that comes in this case only comes from Mr. Denolf's clients.
That seems like splitting hairs, counsel.
Well, Your Honor,
I mean, don't people commission paintings all the time?
yes, Your Honor. And assuming arguendo that this court found Mr. Denolf's work did pass the first part of the Spence test, it doesn't pass the second part, which is that the work convey a particularized message likely to be understood by a third party. Now, while Mr. Denolf's work may contain artistic elements, it doesn't contain any identifiable message that is likely to be understood by a third party. Mr. Denolf makes a
I'm
variety.
sorry. The message of this is a wedding, this is a non-traditional wedding is not a message. Is that your argument?
Your Honor, our argument that there is no message Essentially, Mr. Denault provides decorations, not anything that would identify as a distinct and succinct message that could be recognized by a third party. Because of that, it fails the third prong of the Spence test. Now, moving to my second point, the Court of Appeals correctly found that Section 3 is a content-neutral regulation and thus subject only to intermediate scrutiny. Now, earlier opposing counsel identified the controlling case in this matter to be Turner, and he's correct. However, what he didn't mention was that one of the most key fundamental points that this court used in deciding Turner's application was whether or not it was a content-neutral law.
How is this content neutral if it's specifying that Mr. Denault can't choose to or can't choose to decline providing messages, if we want to call it that, or some sort of expression to those he doesn't want to serve?
Your Honor, the best answer to your question is to actually compare Turner with a case this court has decided, NFLA v. Baraka. Now, that case was decided in 2018, and it determined ultimately that an abortion regulation in the state of California that specifically prescribed the words crisis pregnancy centers were to provide to people coming and seeking their care was content-based, because it directly stated the exact message that they were to apply and that those healthcare clinics were to tell their clients. Here, in Turner, the FCC regulation being considered was a regulation that required local broadcast providers to set aside a certain amount of airtime for local channels. It made no specific prescriptions as to whether how it was supposed to be divided, what channels were to be put on, and thus ultimately left the decision up to the broadcast providers. Here, if you can turn your attention to Section 3 on page 14 of the record, it states plainly, no public place of accommodation in the city of Nur engaged in commerce shall refuse to serve or provide service or sell goods or services to any person on the basis of race, sex, sexual orientation, national origin, or residency status. That on its plain meaning is a content neutral regulation because it does not disfavor favored speech from disfavored speech. It does not attempt to put words into the mouths of the people that violate it, and it treats everyone who violates Section 3 equally. For example, if Mr. Denault were a person that believed the only correct form of marriage was between same-sex couples, he would be punished under Section 3, just as he has in this case. In its application, it is a content-neutral regulation, and thus the deserving test is intermediate scrutiny. Now, turning to my final point.
Yeah, so how would your, if someone came in and wanted him to publish, say, an overtly racist message, and he said, no, I'm not going to do that. How would you analogize that under the statute?
Your Honor, if Mr. Denault were to refuse to provide service in that case, he wouldn't be violating Section 3. He would simply be saying, I'm not going to fulfill your hateful message, but that's not a decision on the basis of race, color, religion, sex, sexual orientation, national origin, or residency status. It's a decision based off the ideological grounds. In terms of your specific example, I believe, if I misunderstood.
What if it is based on race? What if it's a message that is based on, superiority of one race over another?
Your Honor, if they were to identify that as the reason, then yes, Mr. Denault would have been found to violate Section 3. But the key
But
to
in this case, it's an ideological, it's, the message has ideological undertones state down, right? In our case.
Your Honor, the key distinction for Section 3 being content neutral is it goes both ways. Anyone who is found to have violated one of the protected classes or made a refusal of service based on one of them has violated Section 3. Because it goes both ways, it's content neutral. As I mentioned earlier in the case of NFLA v. Baraka, the specific reason why that was found to be content-based is because it succinctly said that there were 29 words you had to tell every person that came into your crisis pregnancy center, and was thus pushing speech into the mouth of the people that the law was applied to. This is not what's happening here.
Well, also in that case, the court found that even if there were a significant interest, governmental interest, that it wasn't sufficiently tailored because it was under inclusive. I mean, here it seems like it's over inclusive because, Mr. Denault was willing to sell the products themselves, wasn't he?
Yes, Your Honor. However, I would argue that this actually references my third point, which is that the levels of intermediate scrutiny are passed with Section 3's application. As this court found in Curley, that one of the key distinguishing factors in this case is whether or not Mr. Denault's business is a public accommodation. Now, because it's a public accommodation, as this court has held, it's well within the state's power, according to cases such as Norwood and Reed, And if I can find it here, to Riley v. National Federation of the Blind, combating discrimination is well within a significant government interest in terms of passing the first prong of intermediate scrutiny. And I believe your question was specifically tailored to the second prong, which is that in order to pass intermediate scrutiny, the suppression of free speech has to not burden anything overtly necessary or cannot burden free speech as much as absolutely necessary. However, in this case, I would ask the court to look back into its history. One key case that this court decided was with Katzenberg. Now, in that case, this court held that refusing service based off of race, essentially, in that case, the question was whether or not it was a violation of the 14th Amendment for a restaurant to tell Black customers that they could take their food elsewhere, provide services to them, but they just couldn't eat in the restaurant. This court found that was a complete denial and went against the government's public interest in terms of promoting a anti-discrimination statute.
But we didn't have to confront the issue of the impact on someone's free expression in that case, right?
You're correct, Your Honor, and we realize that this is a difficult conflict to resolve. There are essentially two rights being pitted up against each other: the right to free expression and the right to be free from discrimination. However, as we've shown in this case, this does not burden more speech than is necessary. Mr. Denoff is free to not put his logo on various items. He's free to disclaim that he does not support this message in terms of when he provides his services to the customers or to the entire city of Newark. However, what he may not do is refuse service based off of someone's sexual orientation. This is well within the governmental interest in promoting a tolerant community, combating discrimination, and ensuring that the city remains open to 30,000 LGBT members as reflected on page 7 of the record.
So hypothetically speaking, if he had provided everything that the customers wanted, but also required in his contract with the customer that they display prominently a sign that says that this business had a moral objection to this marriage, that would also fall, that wouldn't have been a problem under the statute.
Your Honor, there are a couple of freedom of speech issues within that question, but in terms of specific reference to the section 3, the city of Newark would argue that yes, it would essentially allow the city to serve its interest in protecting its diverse citizens, while also allowing Mr. Denoff to have his freedom to express what he believes. The city recognizes that this is a hard case to resolve because of those two issues. However, based off this court's prior precedent, the lower court circuit's decision in this case should be affirmed. And it's because of that we ask you to affirm their decision today. Thank you.
Good. Any other questions?
May it please the court. My name is Ryan Thurber Fishbeck, and I, alongside with my co-counsel, Mr. Gunnar Osteen, am representing the city of Nair. Now, this case ultimately is about the common good. In this case, the common good is the city of Nair's obligation to protect its citizens from violent crimes and discrimination. Ultimately, we are asking you today to affirm the ruling of the 14th Circuit and hold that sections 3 and sections 4B of City Ordinance 417 did not violate Mr. Denoff's First Amendment right.
So in the city's viewpoint, the denial of service to someone is equal to a violent crime. Is that correct?
Well, Your Honor, when I said that this case, I suppose I should have more specifically stated I was speaking towards my issue. Particularly to wit that the city's refusal to honor a contract with Mr. Denoff was based on his donations to groups that the Attorney General of the state of Olympus has designated as hate. And City Ordinance 417 was enacted to promote tolerance and was enacted after, as the record shows on page 5, a rising trend in crimes against LGBT individuals.
Is there any evidence in the record that these particular groups engage in violent conduct?
No, Your Honor, as footnote 4 notes that there is no evidence that these groups engaged in violent conduct themselves. However, the record is silent as to whether their message is somewhat contributing to that fact. Nor has Mr. Denoff ever disputed prior to this the Attorney General's right under the use of executive power to designate these groups as hate groups in furtherance of the state of Olympus's interests and the city of Jersey.
Council, if you opened the statement that this case is about the common good, but isn't it also in the interest of the common good for the city to take the best contract at the best price without regard to the views of people contracting?
But argue that there are multiple common goods at stake in this, Your Honor, and in this case, ultimately protecting citizens from violence and discrimination probably outweighs whether or not someone should be granted a 75.
But again, I think you just said there's no causal link between violence and the contract, right?
There's no causal link between the contract itself and violence. However, the city does have an obligation or the right, at least, to disincentivize speech that it believes contributes to a threat to a large portion of its society. Over 10% of the citizens of Olympus are members of the LGBTQ community, as shown on page 5 of the record. And this is the 6th highest percentage of such individuals in the entire United States. This is a sizable amount of property taxes and various other sales tax and economic interests within the state. Plus, these citizens have the right to be free from discrimination and harm.
Does the city keep similar records about how many citizens hold beliefs that are similar to Mr.
Your Honor, I'm unaware of this because it's not stated in the record. Presumably, these statistics are available and could be gotten. I am not certain about how the statistics involving LGBTQ.
And there's also nothing in the record to even any common harm. This gentleman have this contract, correct?
Not directly, Your Honor. Although my first point is that this court has long held that the state and government employers can choose to associate with who they want. Here, the relevant case is Broderick versus Oklahoma. And in Broderick, this court held that the state of Oklahoma could broadly ban its employees from associating with political parties or soliciting on their behalf in any way whatsoever. Ultimately, the Broderick decision suggests that the court thinks it's constitutional for the state of Oklahoma to ban members or ban their employees from being members of even major American politics.
So let's ask your colleagues on the other side the question, is there an employment analogy here, or is there some other analogy because this is a contract?
Ultimately, while Mr. Nulp is under contract, I believe he should be classified as an employee. But even if he were not classified as an employee, this contract is subject to yearly renewal at the will of the city of Durham. So my argument or the city's argument ultimately proceeds in 3 parts. The first is that this court has long held that the state and federal government can associate with who they choose and can broadly restrict their employees. The second is that the 14th Circuit properly applied intermediate scrutiny to this case. And the third point is that ultimately the 14th Circuit was correct in noting that the Robel or the standard set forth in US Robel does not apply because this is not a case about membership. To my first point, this court has held that the state and the federal government broadly have their right to associate what they want. I've already spoken about the standard set forth in Broderick, which held that the state.
How does Mr. Knowles' contributions, monetary contributions to those particular organizations have any factual or other nexus with his fitness to provide these particular distinct services to the city? Isn't that part of the inquiry?
Well, ultimately, Your Honor, by providing this contract to Mr. Denault, knowing that he donates to groups whose message they do not want to endorse, the city could, 1, be seen to endorse them, and 2, they have the right, as this court has held, to not provide funds through him as an intermediary for these sorts of organizations. This case is similar to Walker v. Texas Division of the Sons of Confederacy, where this court decided that the state of Texas had no obligation to place Confederate flags on license plates, even though the state was under a general policy of providing custom decals on license plates to individuals. Here, the court held.
But that's a sort of a different analysis, right? I mean, these are official, I mean, almost like a forum that it is created by the government. It carries an official governmental brand, as being an official license plate.
And it's mandatory. Everybody has to put it on the, I'm sorry, you don't have to put a flag, but you have to put a license.
Well, Your Honor, I'd like to draw 2 distinctions there. The first is that the signs that Mr. Denolfo is providing are for city events and are being used by the city. So in some ways, I believe this would cut in adverse, while it's not directly analogous.
Well, he's not publishing his donation to these organizations on the materials that he's creating for the city.
Your Honor, but they are a matter of public record, which any individual could presumably find out. And Mr. Denolfo's logo is prominently displayed on all the products he provides. So thus, the city could be fairly interpreted by a reasonable third observer as having endorsed Mr. Denolfo's beliefs. This brings me to my second point, and this is that the 14th Circuit properly applied intermediate scrutiny. As my co-counsel mentioned, the two-pronged test laid out in Turner versus FCC is what's happening. The Turner test requires two things. One, that the state show a compelling or vital interest in the suppression of First Amendment rights. And two, that the suppression that the statute provides for is not overly burdensome on freedom of expression or speech. Here, I would argue the state does have a compelling interest in suppressing certain types of speech. The state has an interest in protecting citizens against a rising trend of crime. As it stands today, and as is noted on page 5 of the record, bias-motivated crimes in the state of Olympus against LGBT individuals are 33.6% of violent crimes in total. As such, this seems like a fairly compelling interest and one that's vital to protect these citizens from harm and continuing discrimination. Second, with respect to Section 4B specifically, Mr. Denolfo's freedom of association is not particularly burdened. Mr. Denolfo is free to go to meetings. Mr. Denolfo is free to be a member of these organizations. Mr. Denolfo is free to say he approves of these organizations. He merely may not donate. He's not required to do anything positive. Section 4B.
Well, isn't the practical reality, though, if you want to be a member of an organization, you're probably going to have to contribute some money. So I mean, when we're supposed to consider the practical impact of this limitation on Mr. Dole's right to associate with those organizations if he chooses.
Your Honor, Mr. Denolfo has in no way claimed that this affects his membership. Ultimately, he has merely said that his right to associate was limited, but he does not claim to necessarily be a member or have chosen to associate. This contention was never made. So it's hard for me to see how it restricted his membership. Moreover, many political, religious, and other organizations don't require membership fees. If Mr. Denolfo wanted to make that part of his case, this should have been raised at trial.
He did say that it limited his right to associate with those groups, but he didn't explain how. Is that correct?
Correct. More importantly, I would like to call Your Honor's attention to page 4 of the record. When Mr. Denolfo was being told his contract was not being renewed, he did not respond that this is a violation of my First Amendment right. Mr. Denolfo responded, and I quote, "I'll be damned if I pay $2,000 to get a $7,500 contract."
Well, doesn't that almost sound like I mean, it's almost sounds like he was extorted to find being asked to pay to another group. Doesn't that sound like more of an immediate response to being asked to pay money to a different group?
I'm not certain I agree with that characterization. Your Honor.
I mean, I know that Section 5 is technically not part of this case, but how can you say that Section 4 is narrowly drawn to serve a significant government interest? When Section 5 just says, but then again, if you pay to some other organization, then we can just go on down the road and continue the contract.
Your Honor, by providing equivalent funds that would promote the interests of citizens that the state is trying to protect, you could say that that in some way accomplishes the aims of the statute. It's also giving individuals an ability to cure, perhaps because they're donating equally to both sides of the aisle, as it were. So if someone donates to one organization and forward and gets, it shows some form of neutrality in a way that donating purely to
Are
one
you
side.
analogizing this to like carbon offsets that they use in environmental contexts?
That would be a fair characterization of what I just said, Your Honor. So more recently, with respect to intermediate scrutiny being applied, in 2015, this court decided US v. Eichmann. In that, the court ruled that strict scrutiny should only be applied when the government's interest is directly related to suppression of speech. So ultimately, in Eichmann, the court ruled that strict scrutiny should apply because the government was trying to restrict burning flags for the purpose of protest, but allowed burning flags for others. Finally, I would note that the 14th Circuit correctly applied the US v. Robel standard. In US v. Robel, it was held that broad members of the Communist Party could not be prohibited from being members of defense facilities or being employed by the government. However, membership is not of state. As page 14 of the record shows, section 4B says nothing about association or membership. It merely talks about donation. As I noted earlier, or as the city noted earlier, Mr. Denault can freely join these associations. He can freely be a member, he can attend meetings, he can speak of their beliefs. For these reasons, we ask that you affirm the 14th Circuit's decision and hold the city ordinance 417, sections 3 and sections 4B as applied to Mr. Denault do not violate his First Amendment rights. Thank you.
Council, just to remind everyone, you have 1 minute for rebuttal.
Yes, sir. May it please the court, I would like to address 2 points my opposing counsel made in rebuttal. First, respondent turned us to page 14 for many of his arguments of the record that states no public place of accommodation in the city shall refuse goods or services based on sexual orientation. However, the respondent did not address the fact that Denault was still willing to provide goods despite his beliefs on sexual orientation. Second,
Council, it does say services also, not just goods. And he was denying service to the client, the potential client. Isn't that correct?
yes, Your Honor. Your Honor, respondent, to my second point, the respondent and the opposing counsel distinguishes against US v. Robel purely on the basis of membership. However, as Justice Ho said, members may also be required to donate money. And additionally, in US v. Robel, the court also stated that the standard was that a statute not consider an individual who could be passive or inactive, that he may be made unaware of arms. Thank you.
Thank you very much. The case is submitted. We are adjourned.
Thank you so much. If you're watching, we're gonna let the feed for a few moments while the judges do their hearing, and it will be back on for the feedback and for the announcement of the winner. Welcome back, everyone. We have reached the portion of the competition where the competitors will receive feedback from the judges, so please stay tuned for that.
That my cue. I didn't introduce the panel at the beginning, so we'll just introduce ourselves as we give our comments. And I'll start with,
Good afternoon, good evening, and thank you guys so much for being here, and congratulations, you're in the finals. Great. My name is Seth Hopkins. I'm a special assistant county attorney here in Harris County. I don't know, you guys are not from Harris County, or you're not from
I am.
Harris County? You are, okay, so we are very proudly the third largest county in the country now. And under the Texas Constitution, our office is tasked with the sometimes good, sometimes terrible job of representing all of our elected officials. So that's what I do in the job.
Hi, everyone. My name is Yvonne Ho. I'm a United States Magistrate Judge here in the federal courthouse in Houston. And I'm a proud graduate of the school 2006 class. And congratulations to all of you for not only just dedicating the time, but obviously doing a fantastic job. I mean, I don't think I could have found my way into a courtroom in my first year, much less present an argument as well as all of you did today.
I'm Megan Hassan. I'm a justice on the 14th Court of Appeals in Houston, covers 10 counties. Harris County being the largest of them. Again, just congratulations for getting here. We understood that your time to prepare for this was also pretty limited. So we were extra impressed by your preparation, given the short amount of time that you had. So, Mr. Hopkins, go right ahead with your comments.
So we'll start with the critiques. We'll start with the petitioner, speaker one, speaker two, and then go right down. Speaker one, first of all, great pace, great signposting in the beginning. You explained to us exactly where you were going, what you were going to talk about. I sense, you were easy to follow. I like that you started talking, for example, about the tests that we use. I think you were getting into intermediate scrutiny. We wanted to hear a little bit more about that, the standard that we want. And we wanted to hear a little bit more about the cases. One thing to be aware of, you did need some time on the board, and sometimes that's a good thing. And the judges sitting next to me would probably thank you in some cases where the time is not needed. But in this case, I think there were a lot of issues that maybe you used that time. And you knew the record, you were 7 of the record, did a great job with that. And I feel like sometimes we bogged you down a little bit got you sidetracked with questions, which is what we're supposed to do. But don't let our questions phase you in any way. Just keep right on rolling. If you ask a good question, a bad question, whatever it may be, get in, get out, and don't let it phase you. All right, second speaker for petitioner. You really excelled at answering questions, and I could tell you knew the facts, you knew the record. You were very poised, you were measured. You did something with the Chief Justice that was really nice. You said, and I wrote it in quotes, "Your Honor," and they rephrased the question. And that's a very good thing because it respects what you're being asked. It was, and at the same time, it sort of maybe phrases it in a way that makes it easier for you to answer and easier for us to understand. It was really nice. First speaker and the respondent. I was wanting to hear more about the government's freedom to contract and ability, that sort of competing interest. You did a good job. And I think that would have been a direction to kind of keep going with. Pace was great. Signposting was great. You had your 3 points, the fact that this is not artistic, you talked about section 3. Your furniture builder, what did you guys think? It was an interesting analogy, but maybe subject to attack. Because I immediately thought, well, people commission paintings and they tell the artist, I want you to be, so I think there are a couple of ways of looking at that, maybe. Loved your enthusiasm, really good, top notch. And finally, good use of the record for everybody, by the way. And then finally, case about the common good, I think that tripped you up a little bit because as working for the government, like the first thing I think of is what common good when we look at a contract is we just want the best deal for the people. And so, there's sort of a counter argument that you maybe it's not always in the common good politics. I think that you had some red herrings. You're an excellent speaker, but I don't know if the statistics were necessarily helpful because there was no causal relationship between the demographics of the community and any harm that was contract. And that's not your fault. That's just something that the record didn't give you. That's all I've got. Great job.
All right, let me start. First of all, I think I have some of your names, but not all of them. So bear with me. Is it Mr. Abakwe?
Yes, ma'am.
Okay. I echo what Mr. Hopkins said. You have a really nice demeanor at the podium, and I think it was nicely paced. I did think you had a bit of a challenge getting back on your script when you got pulled off on questions. And that's something that takes a lot of experience. And obviously you didn't have a lot of time with this problem in particular, but trying to get back on message when the judges are pulling you into different areas of your argument and the case law. So that's just something to work on is pivoting back to the message that you want to convey. I did find the characterization, to get a little bit into substance of what the rights at issue were a little bit awkward at times, like the compelled speech right. I don't think there's a right to compel speech. It's more of a right to be free from compelled speech. So there were some phrases like that were a little bit awkward in terms of how you characterize the issues in the case. Also, and I think this actually applies to everyone. If there's a case that you want to discuss, I think it's more helpful for the listener if you state the principle from the case first, and then plunge into how the analysis supports that principle. Because that way, as a listener, I can see where you're going with it. It sort of sets a thesis for things that follow, rather than just saying the case first.
I agree with this, but I will tell you that in practice, 99% of litigants will do it the other way.
I know,
Like,
but it is, to me, it's still
Right,
difficult
I
to follow now on the bench. I'm like, because I will have read everything.
right.
And so I'm like,
What
which
is
case
that? What
that,
is that case
exactly. So
Right.
then you lose me already for the first few seconds as I'm going through a mental Rolodex, like which case was that? Which case was that? And so if you start with the principle first, as the court held in Healy X, and then say that case supports us because of why. That I think that's just, it's easier for the court to follow. It's like spoon feeding the judges because nobody's going to know the cases as well as you do. As you'll have spent the time in order to prepare a brief and then an argument potentially. All right, Ms. Ammer, is that right? Okay. I thought you had really great poise and clarity at the podium. I appreciated that. You conceded things that you needed to concede. And I also wrote down when you were having trouble understanding what Justice Hassan was saying. I think that there's a little tweak you could make to what you said. Just say, may I rephrase what I understand to be your question? And it's a way rather than saying, I don't want to answer your question. I want to answer the question as I understand it. It's a very nuanced thing, but I would say in real courtroom practice, there are some justices are really sensitive about, I know, we all know people, the sensitive how you put something. Also, I will pivot back to Mr. Abakwe. The one very minor thing, even at the beginning, when Justice Hassan starts to speak and you're answering, make sure you stand. And even making announcements, just all a very formal court proceeding, things like that. And like I said, for some judges, that matters a lot. All right, going back to Ms. Ammer. I felt like the rebuttal was very rushed. Now, obviously, there is only so much you can do 1 minute. But instead of addressing 2 issues in a minute, you address one thing because you focused on sort of the language of the statute, and it was sort of very easy for Justice Hassan to say, well, but we're talking about goods and services. So that just sort of undercut everything, and it ended up expending time on something that you didn't have the opportunity to follow up on. So I think that either you reserve more time for rebuttal. I think 2 minutes to me is minimum.
Right.
Minimum. Otherwise, you really can't say anything. And even then, I would be hesitant to try to inject two separate issues in that 2 minute. You maybe just, if you had a very narrow factual point, say, Your Honor, opposing counsel mentioned this portion of the record, but actually there's another portion of the record that says something different. You know, that way you could work into, but otherwise you can't cover anything meaningful in that short amount of time. And then let's see, Mr. Osteen. I thought your presentation was excellent. You also showed an ability to pivot. When I was asking you hostile questions about, you know, one point of the Spence test, you were able to align right into the second one and say, we went on both. And so if you sort of want to leave the court with a message that even if you disagree with me on this one, there's another reason that we should win. And I thought that was really professionally done. And then it's the same general point, just to, if you lose track of where you are in cases, some point you mentioned, there's this case and this case, and I can't remember the other third case. Don't even mention the third case. Just stick with the ones that come to mind. And if you're talking, you recall that third case, slide it in at the end and say, there is also a third case. Because what you don't want to do is signal to the court that there's something you want to say you can't recall, right? But all of you had excellent command of the record. And I didn't see anybody reading from notes, which is impressive. And then I didn't have your last name. I have your first name as Ryan. Is that correct?
Correct.
Is it Chris?
Fishback.
Respect.
Fishback. Okay, thank you, Mr. Fishback. And actually, it applies to both of you. When you pick a theme, you got to be careful that the theme itself isn't so broad that it's easy for someone to come right and attack you. Common good is very broad, and it is, let's just say it's in the eye of the beholder. Because it is just as easy for a judge who is hostile to say, well, isn't the common good in protecting people's free association and free speech?
Yeah.
Right, exactly. Right.
We had a discussion about changing it, but we
Right.
just couldn't think of.
I know.
But you are right, that actually did happen.
Yeah, and so you know, something that is, what you want to do is create a theme that makes the answer, it sort of dictates an answer. The way you cast the question indicates what the answer has to be, rather than something as broad as we're talking about the common good. I was like, well, they're talking about the common good too. All right, there was Mr. Fishback, you had a couple of moments when you were fishing for words but you know, you were able to recover very quickly and easily, sometimes just taking a beat and having just a half second of silence is helpful too. And it's also helpful to the listener so that we have an opportunity to breathe as we're processing the information that you're imparting. But everybody, excellent job.
So obviously, they said a lot, and I'm going to focus on a couple little things, but also kind of procedural tips for going forward, because obviously this is your last round here. So I would hope that maybe I'll give you some advice that you can use in future moot court competitions. So just kind of individually, Mr. Bakwe, I think you had really compelling arguments. You seemed quite nervous, which is totally natural and will go away as you practice it more. So I have faith in you. Ms. Amr, great thinking on your feet. And you were very, very competent and sure of the record, and it was very impressive. Mr. Osteen, this is actually something both of you did. And this is kind of more of a practical tip for future reference. When I came out and I asked you to make appearances, that is how the court would normally do it. You don't need to introduce yourself again when you get to the podium, because we already know who you are. We probably have document that says who you are.
That's a good point.
And so you've already told us who you are and who you're representing. That takes up time that you could be using on your argument. And as Mr. Hopkins said, the judges love it when you give back time. And so, you know, if you grab that time from the beginning and then you give it back to them at the end, then they'll be more favorable to your side anyway. So you were confident and sure of your answers and the record too. Two criticisms though. One, you you spent a lot of time talking about scrutiny. You mispronounced it. And you continue to, and so just make sure when you're going through practice rounds that you're nailing all the important vocabulary in that particular argument. And the other one is for both of you, there were times where you were speaking and a judge was trying to ask a question, trying to break in to ask a question, and you weren't paying attention to us and you weren't taking the cues from us that you needed to be. These are conversations between the bench and the litigants. The vast majority of cases on appeal get disposed of on papers, on the briefs. And so when you have an oral argument, it means that the court has deemed this worthy enough for you to stand up and talk to us because we want to ask you questions and we have questions about what you've written. And so just, again, pay attention to the judges and kind of be over observant about whether or not they want to ask a question. Mr. Fishback, again, good knowledge of the record. I can't really add anything more to what they've already said. But I think that you all did a phenomenal job, especially given the time. I'm very impressed.
I mean, this material is
Yeah.
dense.
It is,
Yeah.
it is dense.
It
It's complicated
And
for even very experienced lawyers.
It's dense, there's something for everyone in the case law. And it's probably an issue that's gonna be for the Supreme Court in the next few years, so we'll see what happens.
I think next year, actually. Yeah. It's already teed up, it's ready to go.
Thank you so much for giving up time,
Thank you.
No, absolutely.
especially on a Saturday. Come out and hang out with us at the coolest place in the world.
This is wouldn't have it any other way.
Congratulations again.
Yeah,
Thank you.
absolutely.
Okay, thank you, judges. So now I'm gonna announce the winners. What a great competition so far. I think our finalists got some really great feedback that I know they'll take with them into the future. But now is the time to announce the winners. So the winners of this year's 2023 John Black Report competition, sponsored by Haynes and Boone, is Team 8, Gunnar Osteen and Ryan Fishbeck. And best speaker of the final round is Gunnar Osteen. Let's give a round of applause. Thank you.